Hello, everyone. Welcome to the Wills, Women, and Wealth podcast. I'm Elsa W. Smith, your Maryland estate planning and probate attorney, and I'm thrilled to have you with us today. We're here to empower women who value their health, wealth, and the legacies they're creating. This podcast delves into a diverse range of subjects encompassing finance, law, mental and physical health, and beyond. Our commitment is to furnish you with invaluable insights, engaging expert interviews, and enlightening episodes that address your questions on wills, estate planning, and probate matters. Remember, this is your community, and we want to hear from you. Engage with us, ask questions, suggest topics. Let's build a dialogue. Reach out to us on social media or leave us a comment below. Your input fuels the conversations we have. You can find all of our episodes on YouTube, Spotify, and Apple Podcasts. Be sure to subscribe and stay tuned for our upcoming content. We appreciate your support, and if you enjoy the podcast, please consider leaving us a 5-star review. Your review helps amplify our reach and brings our content to more listeners. And now, on with the podcast. Today's episode in our Probate Story series is entitled Second Marriages and Probate: The Complexities of Dying Without a Will. With Make a Will Month wrapping up, it's the perfect moment to explore a crucial issue that impacts many families: the importance of having a will and the complexities of intestate succession. We've encountered these challenges with our clients, and today's story is drawn from one of those real-life experiences. To start with the basics, a will acts as a roadmap for distributing a decedent's assets. This legal document allows you to outline your wishes clearly, appoint a personal representative to administer your estate, and ensure your loved ones are provided for as you intend. The term decedent refers to someone who has passed away, while the personal representative is the person chosen to manage the estate. This role involves handling the decedent's assets, settling any debts or taxes, and distributing the remaining assets according to the will, or state law if no will is present. When someone dies intestate or without a will, state laws dictate how assets are divided, which can lead to complications. Now, you might think, well, the state has a process for this, so it should be straightforward, right? Unfortunately, it's not that simple. Intestate succession often leads to outcomes that the decedent may never have intended. And because these decisions are made according to a one-size-fits-all legal framework, they might not align with the unique dynamics of your family or your personal wishes. In Maryland, as in many other states, who gets your property when you die intestate largely depends on whether you have a surviving spouse, children, parents, or other close relatives. The laws are designed to ensure that your closest family members receive your assets, but this can create unexpected challenges, especially in blended families or situations where relationships are complex. Before we continue, let's take a moment to hear from our sponsor. Are you in Maryland or DC embarking on your estate planning journey? Let us guide you through the process. Join us for a complimentary 15-minute call with a member of our team. There's no obligation. Check out the show notes for the scheduling link. Your first step towards securing your family's future starts here. Let's continue. One of the significant challenges associated with intestate succession is the potential for family disputes. When an individual passes away without a will, their relatives may find themselves in disagreements regarding the distribution of assets and who should represent the estate during the probate process. These disputes can strain or even fracture family relationships, leading to legal battles that are not only emotionally draining, but also costly and time-consuming. Let me share with you a hypothetical scenario to illustrate just how complicated things can get. We'll call our client Jessica. Jessica recently experienced the unexpected passing of her husband, whom we'll refer to as the decedent. The decedent was a Maryland resident, and his name was the only one listed on the deed to their home. Unfortunately, he passed away without a will, and now the family is facing the complex reality of intestate succession. To add another layer to this situation, the decedent had 2 adult daughters from a prior marriage. These daughters cared deeply for their father, but his decision to remarry caused some tension between them and Jessica, leading to a strained relationship. Aside from the house that was solely in his name, the decedent also had an extensive art collection that he had curated over years of traveling the world. This art collection was not just a financial asset. It was a deeply personal collection, one that held significant sentimental value for the decedent and potentially for his daughters as well. So what happens now that the decedent has passed away without a will? Under current Maryland law, if a person dies without a will and leaves behind a spouse and children from a prior marriage, but no minor children, the spouse receives the first $100,000 of the property subject to probate and then half of what's left. The remaining half is divided among the children from the previous marriage. Now, laws are subject to change over time, so always work with an experienced estate planning attorney in your jurisdiction to have the most current legal information at your disposal. In Jessica's case, this means that the probate court would follow the formula I just described for distributing the decedent's assets. But it's important to note that this law applies only to probate assets, those assets that are subject to the probate process. The decedent named Jessica as a beneficiary on his bank accounts, so those accounts are not considered probate assets. They pass directly to Jessica without going through probate. This is a crucial distinction because it shows how different assets are treated differently under the law, and why simply naming beneficiaries on accounts isn't enough to ensure your wishes are carried out for all of your assets. So what are the probate assets that the court has to consider in this case? So primarily the home and the art collection. These are the assets that will be subject to the intestate succession laws. Given the strained relationship between Jessica and her stepdaughters, this could easily lead to disputes over who gets what. For instance, the stepdaughters might feel that they should inherit a significant portion of their father's art collection, especially if certain pieces have particular sentimental value to them. On the other hand, Jessica might feel that as the surviving spouse, she should have the right to retain the home where she and her husband lived, along with some of the art that they had enjoyed together. This hypothetical scenario highlights the complexities and potential conflicts that can arise when someone dies intestate. The state's formula for dividing assets is designed to be fair, but it can't account for the personal relationships and emotions involved. And in many cases, it doesn't reflect what the decedent might have wanted if they had taken the time to create a will. For example, the decedent might have wanted to leave specific pieces of his art collection to his daughters, while ensuring that Jessica could remain in their home without financial hardship. He might have intended for his estate to be divided in a way that respected both his love for his wife and his daughters, but without a will, those intentions are not taken into account. Instead, the family is left to navigate the complexities of Maryland's intestate succession laws, which may not align with anyone's wishes. To recap, the main point of this episode is the crucial role a will plays in estate planning. Having a will gives you the power to decide how your assets are divided, safeguards your loved ones from potential conflicts, and ensures that your wishes are respected after your passing. Without a will, these important decisions are left to the state, which can result in outcomes that may not align with what you or your family would have wanted. If you haven't already, I urge you to consider creating a will or updating your existing one to reflect your current marital situation. As Make a Will Month draws to a close, there's still time to take action today. It's one of the most important steps you can take to protect your family and your legacy. I invite you to schedule a complimentary 15-minute call with a member of our team. The link will be in the show notes. Thank you for joining us on this episode of the Wills, Women, and Wealth podcast. I'm Elsa W. Smith, your Maryland estate planning and probate attorney. Until next time, stay informed, stay empowered, and take control of your legacy.